May it please my Lord, I appear together with Mr Thomas and Mr Craven for the appellants,
Yes.
my learned friends Mr Havers and Mr Shelton for the respondent, and my learned friends Mr Hussain Luck and Mr Joy for the intervener. My Lord, can I start by thanking the court for sitting extended hours to hear this case? I understand my Lord has seen a copy of a draft anonymity order.
Yes, we have, and I think at the moment what we're inclined to do is make the order on a provisional basis and reconsider it at the end of the proceedings, because we're not entirely sure, and we may need some help as to whether it is necessarily a case for anonymity. It may to some extent depend on what is disclosed in the proceedings, I suppose, even, but
Yes.
On the face of it, it might be thought not to be a case for anonymity, but it has been hitherto.
It has. And perhaps what I can do, my Lord, is forward to the court the order that was made below, the evidence upon which that was based, and, if necessary, just a few short submissions in writing supporting the maintenance of an order.
Well, that would be helpful, and you'll show your colleagues and give them the opportunity to respond. So on a provisional basis, the court will order that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of her or any member of her family in connection with these proceedings.
My Lord, I'm very grateful.
And we will have since we are sitting early, though not quite as early as we agreed, we will have a break sometime in the middle of the morning.
Thank you.
5 minutes. Thank you.
My Lord, can I divide my submissions along the lines of the two constituent elements of Article 8? So firstly, whether the decision to prosecute SXH was capable of engaging her rights under Article 8.1, and secondly, assuming her rights were engaged, the separate question as to whether the interference was justified under Article 8.2. And before turning to those substantive submissions, can I set out 5 features of the claim that will inform my arguments both on 8.1 and 8.2? The first 2 points concern the nature of convention rights generally, and the remainder address the particular facts of the appellant's case. So the first is this. My Lords, it's trite, but it merits saying. The Crown Prosecution Service is a public authority within the meaning of Section 6 of the Human Rights Act. It enjoys no special immunities under the Act, nor are there any relevant statutory exceptions in respect to the work that it undertakes or the manner in which it discharges its functions. The common law's reticence in imposing private and public law liabilities on the CPS is irrelevant to the operation of the statutory scheme, except, as I'll develop later, some of the policy concerns underlying the common law's approach are mirrored in aspects of the proportionality test and the margin of discretion afforded to decision makers. Point 2, where a public authority has responsibilities that require it to make decisions impacting upon the autonomy of others, then almost by definition, their acts and omission will be capable of engaging convention rights. That is an unremarkable feature of societies governed by the rule of law, where the interaction of state and individuals will often have potential legal significance.
What do you mean by engaging?
Well, my Lord, I'm going to come on to that in a moment in a little more detail, if I may. But one of the points I'm going to stress is the distinction between an act that is capable of engaging 8.1, so we're at 8.1 territory, and then the clear distinction thereafter between an assessment as to whether or not there has been a breach of the rights, in other words, whether or not it can be justified. But I'm going to develop that in a bit more detail in a moment, if I may.
And the proposition was that anything, just give me your wording, but effectively anything that affects your private autonomy.
Yes, in the broader sense. Now I'm going to drill down on that.
In the broader sense. Yeah.
Yes, I'm going to drill down on that, though, my Lord, when I turn to Article 8.1. And take the court to some decisions that give us, put more flesh on that bone.
But I mean, an awful lot of things can affect your private autonomy. If you're dismissed from your job, it can upset your home relationships. So that, I mean, that's a wide-reaching proposition that is purely based on consequences.
Well, it is a wide-reaching proposition, and as my lords will see from our written case, we don't there are two ways in which we put the engagement of Article 8.1. One is the broad proposition of consequences, and one is a narrower, is it an act that's deserving of respect?
The nature of the act.
But the broader proposition, we don't shy away from. It's Article 8.1 is capable of being engaged in a whole series of acts of the state. But that doesn't mean there's been a breach.
Doesn't mean there's been an interference.
It doesn't mean there's been an interference, no.
So your proposition is it that the article can be engaged even though hasn't been any interference?
No. Can I, well, look, rather than the problem with starting with a broad proposition, when I'm going to come on to the more detail, can I come back onto that and just answer it direct? Don't want to shirk that question from my lord, but I'm going to answer it directly with a step-by-step argument, if I may, and just at the moment give you the broad features. But so, of course, our case is on the broader sense that Article 8 will be engaged frequently by a whole range of acts, but that does not mean that there will be a breach, because it's a qualified right. And we also say at the outset that we accept that the vast majority of decisions of prosecuting authorities will be proportionate, not simply because of the public interest in upholding the criminal justice system by enforcing laws, but because prosecutorial policy is designed to address issues of proportionality.
Sorry, the vast majority of prosecution decisions will be
proportionate.
Right, but each one has to be justified under Article 8.2, does it?
Yes.
Every single one?
Yes.
Right.
Yes, my lord. Just as a criminal court passing a sentence will have to take into account the impact of the sentence upon the defendant, upon the defendant's family. So it is, we would say, unremarkable that decisions to prosecute will engage Article 8.1, but they will be readily justified. They'll be readily justified because they are almost inevitably, by definition, pursuing a legitimate aim. They will be proportionate because the prosecutorial policy, and I'm going to show that to my lords in a moment, is designed and caters for the test of proportionality. And that is why there is nothing in the appellant's case that results in the opening of floodgates to claims against the CPS. And as I'm going to seek to develop before my lords, liability will only arise in this case because of the particular context. And that is the systemic failures in the treatment of refugees entering the United Kingdom without legitimate documentation, of which this case is an exemplar. My third point turns to the appellant herself, and is this. At no stage did the appellant commit any criminal offence or engage in criminal activity, contrary to the way that my learned friends put their case. Although by presenting a false passport, key constituent elements of an offence under Section 25 were made out, it was subsequently accepted that it was not only not in the public interest to prosecute her, but separately that she had a complete defence under Section 31 of the Immigration and Asylum Act, a defence whose very purpose is to ensure that the acts of vulnerable individuals, such as the appellant, are not criminalised. Now, can I start off by just showing my lords the relevant material on that?
It's a defence which places the burden on the defendant, isn't it?
Yes.
Yes.
Well, there's a reverse. No, there's a reverse. There is a reverse onus in Section 31(3), is it? 2. Thank you. In relation to stays elsewhere and claims that might have been made elsewhere, but that's not the only question that has to be answered before you've established an offence under Section 31, is it?
My Lord is quite right.
Yes.
Can I just take you to how it was dealt with by the CPS? So if we could start, if we may, with the evidence that was before the court below, which came from Miss Sternberg, who was the Crown Prosecutor who made the relevant decision. We'll pick that up in the appendix at MS 4199. Paragraph 16. In my email of 8th of June 2010 to Charlotte Davidson, I'm going to show you those emails in a moment, I state my opinion was that were the claimant to be granted asylum, she would be afforded the Section 31 defence. I should clarify that I am aware that whilst recognition of refugee status is an essential element of offence, it is not the only element, and that by itself cannot be determinative of whether a person is afforded the defence. It was my view that having spoken with Officer Webb and learned of the claimant's explanation for her time in Yemen and the difficulties faced by Somalis living in Yemen, the claimant would be able to satisfy the requirements of 31(2), i.e. should be able to demonstrate she could not reasonably have expected to be given protection under the Refugee Convention in a third country. My view was that, this in mind, the only element of the defence which remained to be made out, the claimant's status as a refugee, would be made out conclusively on the grant of asylum. It was for this reason that I concluded that the claimant's application to dismiss was likely to succeed. It was also my opinion that in view of the particular circumstance of the claimant's case, it would not be in the public interest to pursue the matter to trial.
Now, that was her view at the time when the matter was before the court. But Lord Justice Pitford, in his judgment at paragraph 72, says that you accepted that at the time of the decision to prosecute, the evidential test was met.
Yes.
Is that correct?
Well, my Lord, we've gone back over every document. I should say, firstly, we didn't seek to correct that in the judgment of Lord Justice Pitchford, and we should have done, and I accept that entirely. And we've been through all the documents that we produced for the Court of Appeal and indeed the High Court. We've tried to obtain a transcript of the proceedings before the Court of Appeal. We've only had day 2, and we cannot find that concession.
Well, Mr. Herman, it's quite difficult for this court to accept that it wasn't made, bearing in mind that it's referred to as an important concession and is referred to in 2 separate paragraphs.
Well, my Lord, I accept that entirely. But
I mean, the natural place where one assumes it was made was in oral submissions.
Well, and it was for that reason that we went to the transcripts, and I'm sorry that we haven't been able to provide day 1, where it may have fell.
But it certainly doesn't appear in day 2.
It doesn't appear in day 2, and we simply haven't been able to find it. But, my Lord, I entirely accept that it was incumbent upon me to draw that to the Court of Appeal's attention on receipt of the draft judgment. But in any event, it's limited to the decision to prosecute in December 2009.
Yes.
And what is clear by June 2010 is the acceptance by the Crown. And if the Court would also just go on then to read paragraph 17, it's clear that by June, it's accepted that the defence is made out.
So which is the decision which you say is vulnerable under Article 8?
Well, the initial decision, my Lord.
I thought you just conceded that that wasn't.
No, no, my Lord, the concession, as recorded by Lord Justice Pitchford, is in respect of the evidential test.
Yes.
It has always been the appellant's case that the public interest test wasn't made out.
Even in December?
Even in December.
I follow.
Can we just look at the actual offence, which is under
tab 1.
My Lord, you will find that in paragraph 11 of the Court of Appeal judgment at 4064.
yes.
think in due course you'll have to help us a little on the relevance of the public interest test, because the public interest test isn't a part of law. It's a policy of the CPS.
Yes.
Now, how that translates into a decision to prosecute being within the ambit of Article 8, at least in circumstances where the offence itself is Article 8 compliant and there is evidence that the defendant committed it, will be a matter that you'll no doubt be helping us on.
I will, my lord, and I'll be helping you on it in respect of Article 8.2, where that's most relevant. As to the question of proportionality.
For my part, I'd like help in relation to Article 8.1 about that.
Then I'll certainly address it when I come to 8.1.
Thank you very much.
So my lords have the offence there. I've shown you Ms Sternberg. I was just going to show you the email chain, if I may. And if we could pick that up.
And does,
Sorry, my
do the CPS somewhere deal with the issue about Holland?
With Holland?
Yeah.
They do, my lord. And I was going to show you the series of emails a little later on. Again, if I may do that under 8.2, I was going to, but for now I'm going to show you the emails in June.
Where are we on your list of preliminary points, Mr. Hammond?
We're on 3.
Still on 3, right.
We're on 3.
I think you should be entitled at least to outline those before we...
Well, I am going to come head on to some of the concerns that are raised by the court when I deal with 8.1 and 8.2, and all I am seeking at the moment to do is just to kind of flesh out some key points, which I will come back to, and I will come back to the meat of them, if I may. So could I just show you the emails in June so that my lords have the picture? And this is on my point that there is no criminal activity or criminal offence committed by the appellant. So the first email, if I could ask you to look at, please, is 4301. Now, this is an email from UKBA, the border agency, to the CPS. It's dated the 7th of June, and it follows on from a phone call that is said to have generated quite a lot of discussion. The UKBA, as I indicated earlier, we are concerned about setting a precedent by discontinuing this case due to her asylum claim being granted. Having discussed it at length with my chief immigration officer, Hutton, we would prefer if this case was discontinued on the basis she's afforded a Section 31 defence, this being as a result of Yemen having no functioning asylum system and her limited stay in other convention countries. And then if we look over to 4302 is the response from the CPS. It sounds sensible to me. I anticipate dealing with this tomorrow. I've spoken to Charlotte Davison of the CPS, and subject to asylum grant, my advice, which will take into account your views, is highly likely you should not proceed. It must be right in the circumstances that this decision should be down to the statutory defence and not to a blanket policy decision. Moving on to 4305. Is a further email, 8th of June, from Miss Sternberg to Charlotte Davison of the CPS, copying in the UKBA. And this sets out more thinking of the basis of a decision. Can I ask my lords to read the 3rd and 4th paragraphs? The first starting, my understanding is that the claim. Just 2 more short emails to complete the picture, if I may. 4312 is a CPS email from Ms Sternberg to Ms Swift, dated the 9th of June. We need to have the written decision about asylum, subject to the contents of the decision, which will have made findings of fact. This is not a take-a-stand case, in my view. The whole regime is against proceeding in these cases in circumstances where the case concerns a genuine asylum seeker. I don't see any merit in pursuing an illiterate, vulnerable 18-year-old. In any case, the application to dismiss would succeed, giving the indication of the trial judge. And then finally, 4321. Just at the top, it's an email that just completes the chain. This appears to be after court. An email from Ms Sternberg to the UKBA. I discovered that the appellant had been arraigned, so this was not a dismissal application. The defence application made it appear so. This was listed today for mention, no evidence was offered. No precedent is set by doing this, but my reason given was that with the grant of asylum in these particular circumstances, the defence was afforded her.
Well, now, all this is pointing to the position when she was eventually granted asylum and the prosecution was dropped, but we're not focusing on that date, are we, at all?
Well,
I mean, unless you read this with the benefit of hindsight as having applied 6 months before, it's irrelevant, isn't it?
It's not irrelevant. It's not irrelevant for at least two reasons. The first is because it puts beyond argument or dismisses beyond argument the contention that somehow the appellant was engaged in a criminal activity or was criminal conduct.
But it hasn't addressed so far the issue about the stop in Holland.
Oh, well, my Lord, the stop in Holland, if I can just give you the headlines and we'll look at the documents a bit later. The stop in Holland was raised by the UKBA on arrest as a reason why the Section 31 defence would not be afforded the appellant. Sometime thereafterwards, the CPS raised the issue saying, well, that doesn't work with AS4. There's then another long delay, and I'm going to show my lords the documents, when the UKBA is saying, well, we're not quite sure whether Holland counts or it doesn't count, but we think it probably doesn't count. But a view was taken eventually by both the CPS and the UKBA that the stop in Holland didn't deprive the appellant of the defence. And my lords, we say that's right on an analysis of AS4. They got it right eventually. That's what the House of Lords decided in that case.
I mean, is this a sliding scale situation? In other words, you'll be just looking at the position at the end, but I was suggesting one should be looking at the position at the start. But if that's wrong, are we looking at the position at every intermediate date and asking whether the CPS or anyone else who's relevant acted sufficiently promptly in the 6 or so months between the original?
Yes,
so we are. So we are reviewing every single decision in the course of the prosecution's handling.
Was it proportionate to maintain the prosecution throughout the 6 months in which this young woman is on remand? Certainly.
Mr. Herbert, since you're on the question of whether she, as it were, technically committed an offence or not, can we just dispose of one possibility? I just for a moment suggest it affects the ultimate decision that it's not in the public interest to prosecute this woman, because it no doubt wasn't. But what about the element of the defence which is in 31? 31(1) C. You have to show, don't you, in order to avail yourself of the defence, that you've made your claim for asylum as soon as was reasonably practicable after arrival.
Yes.
What happened in this case, as we understand it, was that she presented the false document on arrival, and when it was queried, then said she was seeking asylum. Is that right?
That's right.
Yeah. It won't, as I say, remotely affect the question of whether there was, by June, a public interest in pursuing the prosecution. But as at the original stage of of appearance at Stansted it was, wasn't it?
Yes, my lord.
Is there an open question whether the claim has been made as soon as practicable, or is there
Well,
not?
my lord, we would say emphatically no, and that this case falls precisely within the ambit of behaviour that Lord Justice Simon Brown identified.
Well, I know exactly what Lord Justice Simon Brown said in Ademi, of course, but if you are in the entrance hall of a safe British airport, surrounded by uniformed officials, is there an argument, or is there not, that you make your claim for asylum as soon as practicable if you say straight away, rather than waiting to see whether the false document will get you through the barrier?
My lord, the appellant's answer to that would be twofold. Firstly, a human answer, and secondly, that human answer records law and our understanding of it.
Yep.
The human answer, my lord, is that presupposes an unreasonable degree of thought process for young, vulnerable people who perhaps have very good reason to fear people in uniform, who won't know about the details of a asylum process, and who are in an entirely alien, foreign environment, heart-pumping,
But this
disorientated.
This isn't how criminal law works.
Well, my lord, it doesn't.
Criminal statute lays down the conditions of commission of the offence, and there's nothing in the statute about whether the individual happens to have a heart pumping in an airport.
My lord, with respect, that's not right, because you can't look at Section 25 in isolation. You have to look at Section 25 together with Section 31. And Section 31 incorporates an international convention whose heart and understanding is all about the actual difficulties that refugees face.
Actually, Section 31 was deliberately intended to be rather narrower than the terms of the article in the convention, wasn't it?
That's right, my lord.
Presented to Parliament on that in those terms, and the provision about which I've just asked, about making your claim for asylum as soon as reasonably practical, is an addition.
Well, my lord.
Your point, Mr. Ham, is that
Anyway,
addressing the question as soon as reasonably practical cannot leave out of account the personal characteristics of the individual making the claim.
My lord, that is absolutely how he put it, albeit my lord puts it more eloquently. But the context.
But then it requires, the concomitant of that is that obviously it may require a bit of time to work out what the personal characteristics and the state of knowledge of the individual was. It does make it, of course, a rather open condition, doesn't it? I mean, it's not as was reasonably practicable in an objective sense, it's as was reasonably practicable for this particular asylum seeker with her particular fears and worries and knowledge and misinformation from the smuggler who had brought her or enabled her to come and so on.
Well, my lord, yes.
So you have to investigate that on your case.
Mr. Hammer, I'm conscious that you're trying to outline your case and being bombarded from several directions, but I do have one question about the ambit of your claim arising from your answer to a question from Lord Manson a moment ago. I've been looking at the claim form, see what the scope of the claim is, and we have it in the at 56 in the appendix. The claim, we've got the claim form, which claimed damages for negligence, misfeasance, false imprisonment, and breaches of the Human Rights Act. Then the particulars of claim. The claim under the Human Rights Act, page 63, paragraph 15, is that the decision to prosecute engaged her rights protected by Article 8, that it was unjustified, in particular, wasn't necessary or proportionate to commence the prosecution prior to the determination of her asylum application.
Yes.
That's, as I see it, the claim that courts were addressing. Now, I point to that because that seems to me to be rather narrower than a sort of running analysis of how did the evidence stand at this point and how did the evidence stand at that point.
Well, my lord, we'll also see that we expanded upon our position in Article 8 in the reply considerably over several pages, starting at page 79 of the appendix. But
Can we just look at that?
yes, of course.
I think Lord Kerr would probably like it if you gave the electronic version.
I'm so sorry. MS 4133 is the start.
Yes.
And the analysis of the decision to prosecute starts over page 4134 at paragraph 3.
So which is the bit you rely on?
Well, my lord will see how we put it generally. I mean, what I should say fairly is that another element of the way that the claim was put under Article 8 was that the decision should have been postponed pending determination of the appellant's asylum.
Well, we've seen that. That was paragraph 15b of that's indeed the claim, that the decision was premature, wasn't. There should have been no decision to prosecute until after the asylum application had been returned.
It is all about this reply, is still all about the decision to prosecute.
Yes, but
Or not to defer prosecution until after the asylum claim had been concluded. So I don't see the sort of running analysis.
well, you'll get it, my lord, if you look at paragraph 2. So the central issue between the parties is whether the decision to prosecute the claimant on the 28th of December 2009
Paragraph, yes.
2, and thereafter maintain the prosecution until the 11th of June amounted to a legitimate interference with her rights.
But where is the detailed analysis of the conduct of the CPS in the 6 months? And was this an issue
Well, my lord,
in the courts below?
It was certainly an issue at trial. We've plainly said pleaded in terms in paragraph 2 that the claim encompasses impeachment not simply of the initial decision, but the decision to maintain. And all of this is without prejudice to the starting point, which is that if the claimant can demonstrate that Article 8.1 is engaged, it's then for the defendant to demonstrate that it was justified. So this is the claimant, helpfully, we would say, trying to sort of pad out the issues, but it's for the defendant to justify.
So, actually, I mean, you say this isn't a floodgates case, but I mean, the logical consequence of your being right is that in every prosecution, the CPS must be in a position, because the burden of proof is on them, you say, falling within the scope of Article 8, to justify each step along the way. Why did it take us 3 weeks to do this? Why did it take 4 weeks to do that? Had you evaluated the evidence of Mr. So-and-so? This is something which the CPS have to do in every case where an Article 8 challenge is made against them.
Well, no, the CPS, with any decision to prosecute, will have to go through a checklist, and it's inbuilt into their code already.
We're talking about the expanded, the justification of everything which happened thereafter.
Even on my broader contention of Article 8.1, which is that Article 8.1 is engaged by the consequences of the prosecution, which we accept will apply in all prosecutions, or nearly all prosecutions. We would say that there's no floodgates concerns that really apply there, because the overwhelming number of prosecutions a decision would have been reached, having gone through a decision-making process that will mean a proportionate decision is reached.
So when you say that Article 8 is engaged, what you're really meaning, I think, in terms of the language of Article 8, is that every decision to prosecute and maintaining the prosecution thereafter is an interference with Article 8 rights, which requires to be justified.
My lord, that's precisely how we put it. I'm sorry if I wasn't clear at the outset, but that is precisely how we put it. And that's why I was trying to open with a general point, that actually there's nothing remarkable about that. There's nothing remarkable about the fact that where a public body take steps that will impinge upon Article 8.1 rights. A, that is going to always, almost infrequently happen in respect of a prosecution. And B, it is not going to open any floodgates because, as I'm going to develop in Article 8.2, it's catered for already in the CPS decision-making process, and the vast majority of prosecutions will always be proportionate.
Now, am I right in saying at the moment you're still just giving us the introductory bit? You're going to
I think we've probably got somewhere in the middle of point 3, possibly.
Yeah.
Point 4.
I'm
Yes.
looking forward to 4 and 5.
There's nothing like good building.
Right. Shall we allow you to do that?
Thank you, my lord. Well, all I wanted to finish off, I mean, my point on point 3 was actually, it's a very simple, but it's an important one for when we've come to analyse this case, which is contrary to what is being said by the respondent. The appellant did not commit a crime. She was not engaged in a criminal activity.
I think we've understood that, but you are going to come back and you are going to develop how it falls within the scope of Article 8 at all.
Yes.
We'll wait for that.
I am.
Okay, so we now come to your point 4. Do we?
We've arrived, my lord, at point 4, which is that at all relevant stages, the claimant was a refugee and was entitled to protection in this country under our international obligations and our domestic law, and was also thereby entitled to, in domestic and international law, from protection from criminal penalty if she entered with no travel documents or with false documentation. And as the High Commissioner in written submissions explains, refugee status is declaratory. She arrives in the United Kingdom the day after her 18th birthday, having fled Somalia as a child. She was a member of a persecuted minority. She witnessed her parents were murdered. She's gang raped in front of her mother. And a year later, she's beaten unconscious by Al-Shabaab terrorists. Her claim for asylum was granted by the Home Office on multiple grounds. And my lords will see the decision at MS 4265. I don't ask you to pull it up now. But the findings were that it was readily ascertainable she was a member of a persecuted minority, that she would be very likely to be at risk as a young woman returning to Somalia, that she could not safely internally relocate in Somalia, and because the conditions for Somalis in Yemen were very harsh, it was reasonable for her to make her way to this country. That's point 4. Point 5 is, as the trial judge accepted, as a Somali, the appellant was never going to be in possession of valid travel documents. The judge concluded that had this fact been communicated to the relevant decision makers in the CPS, it was unlikely that the appellant would have been prosecuted at all. For your notes, paragraph 43 and 92 of the judgments at MS 4100 and 4109. Can I turn then to Article 8.1? And can I make 5 principal points, please? And can I just set out what they are and then turn to each one? Point 1 is, as the court will well know, the range of rights protected by Article 8 are broad and are not capable of exhaustive definition. And relevantly for the purposes of this appeal, they include respect for the personal autonomy of every individual, the right to personal development, and to establish relations with others. The second point is that the threshold for engagement of Article 8 is low, and that it is important, indeed crucial, not to wrongly align the question as to whether or not the act of a public body engages a right with a separate and distinct question as to whether or not any infringement can be justified. Third point is that Article 8 was engaged in this case because of the consequences of a decision to prosecute on her personal autonomy. They were sufficiently serious to cross the 8.1 threshold.
So the consequences for her personal autonomy?
Yes.
Yeah.
And this is what we've termed the broad concept of engagement. Fourth point, which is our narrow concept of engagement, is that Article 8 was engaged because the conduct giving rise to the decision to prosecute was one that can properly be regarded as an aspect of her private life deserving of respect, namely the attempt to seek to develop a life in England and thus develop personal and social relationships with the outside world in a way that she could not do in Somalia. In other words, we say that the Court of Appeal was entirely wrong to simply categorise that conduct as the presentation of false documents. Our fifth point is that there is no principled basis for the respondent's contention that the ambit of Article 8 extends exclusively to an assessment as to whether a given offence is on the face of the legislation compliant with Article 8. And when I deal with this fifth point, I'll deal, if I may, with a decision of the House of Lords in the case of G. Can I start then with point 1, which is the broad definition of Article 8? The Court will be very familiar with this territory. We set out the cases at paragraphs 46 to 52 of our written case, MS 3952. Could I just take the Court to two authorities, starting first with Lord Bingham in Rasgar, which is volume 6, tab 45. And if we could just look, please, at paragraph 9.
Sorry, MS?
MS 1801.
Yep.
So this judgment establishes, in my opinion, quite clearly that reliance may in principle be placed on Article 8 to resist an expulsion decision, even when the main emphasis is not on the severance of family and social ties which the applicant has enjoyed, but on the consequences for his mental health of removing to the receiving country. That's obviously a passage.
Sorry, which is the paragraph you're at?
I'm so sorry, my Lord. Paragraph 9.
Paragraph 9.
MS 1801.
All right.
I've just...
Yes, I see, right.
You see consequences for the mental health of removal to the receiving country. The threshold of successful reliance is high, but if the facts are strong enough, Article 8 may in principle be invoked. It's plain that private life is a broad term, and the Court has wisely eschewed any attempt to define it comprehensively. It's relevant for present purposes that the Court saw mental stability as an indispensable precondition of the effective enjoyment of the rights of respect for private life. In Pretty, the Court held that the expression to cover the physical and psychological integrity of a person, and went on to observe that Article 8 also protects a right to personal development and the right to establish and develop relationships with other human beings in the outside world. Elusive though the concept is, I think one must understand private life in Article 8 as extending to those features which are integral to a person's identity or ability to function socially as a person. Professor Feldman.
On that basis, I mean, any decision to sack someone must inevitably affect their private life, because people rely on their work to establish and develop relationships with other human beings and the outside world. So, I mean,
yes,
Lord Bingham's words, if you take them à pied de la lettre, are rather broad.
Well, my Lord, it is on the broader concept of the engagement of Article 8 possible if it was a public authority that dismisses an individual.
Yeah, but I mean, are you saying, for example, that a decision to dismiss someone is necessary within Article 8?
Well, it could be. It could be within Article 8.
What? Because somebody says, right, the relationships I forge at work are very valuable to me. I benefit from them. They're part of my, they formed my personality. That is a pretty broad proposition, isn't it?
Well,
it means that effectively nothing is not part of your private life.
Well, my Lord, it is certainly possible that if a public authority dismisses an individual, that it would be capable of engaging Article 8. But one would be fairly confident that if employment laws have been followed.
But it's only capable of engaging it if the individual says, I value the relationships I make at work.
Well, I think one could, or one could objectively ascertain that it would. But my Lord, this is why. It depends
on the particular individual.
Well, it may depend upon the particular individual, and this is why I'm seeking at every turn to give stress to the point that Article 8.1 may be engaged, only gives us a tiny bit of the picture. because the controlling mechanism is Article 8.2. And to take the employment scenario, one would be confident in asserting that a decision to dismiss would be justified where people have complied with employment law. And the threshold, as I'm going to again show, although the threshold we will say for engaging Article 8.1 is low, correspondingly, the threshold for a respondent to demonstrate that it is justified is low. And in an employment context, that's going to mean, one would hazard, that if you follow employment law as a responsible public authority would, that's going to demonstrate that it was proportionate.
But I mean, the effect of it's easy to say that every decision involves justification, but it does involve extending Article 8 really in relation to public employees to cover everything. If you have a government department which was relocated to Birmingham, someone can say, well, that's an infringement of my Article 8 rights because I play tennis every Tuesday evening in London. Isn't that that's carrying it quite a long way, isn't it?
Well, there's going to be a threshold requirement that one needs to get over in order to be in Article 8 territory. We say it's a low threshold, but there's an Article 8 requirement to get over that. But it's unremarkable that acts of public authorities that impact upon the autonomy of people are going to be analysed within a legal framework. And Article 8 gives us one way of explaining that. I mean, my Lord, every day when one walks from here to the tube, legal relations are engaged. If I'm barged on the way out of the tube this morning, that's a legal relationship between me and the person who barged. I'm not going to go and sue them for battery, even though technically it might be deemed a battery. There are a whole host of ways that we interact with other people, and the state interacts with us.
The converse way of looking at this, of course, is to pose the question, by what mechanism can Article 8 be excluded from the termination or alteration of the terms of a public employee's employment? What is the mechanism for saying Article 8 is engaged?
Yes. Well, when a public authority is able to take steps that impact upon your autonomy, your well-being, then it's an unremarkable feature that it's an unremarkable fact that might have some implications for employment as a matter of principle. But it makes no difference to employment law because employment law provides the answer on a proportionality test.
Well, you may be right, but if it's all loaded onto Article 8.2, which is effectively your thesis, then the gates of successful claims successful claims may be narrow, but the gates to judicialisation of examination are very wide, aren't they?
Well, my Lord, but on paper, yes, but in reality, no. There's nothing to suggest that. I mean, to take the tube example, the courts aren't overwhelmed with battery cases because of what's going on the tube with batteries every day. There's no reason to suppose that simply because it might be identified that Article 8 is capable of being engaged in a wide variety of circumstances, which is no more than the courts we say have said already in pretty clear terms, is going to lead to a rush of claims with people chancing their luck, funding themselves mainly before the courts to say, chancing my luck to see whether or not it was proportionate. And as I am going to develop, proportionality is inbuilt, certainly into CPS decision-making, but it's inbuilt into all sorts of other areas of public life. As I'm going to take my Lord to my Lord Hughes's judgment in Petherick, a sentencing case, to show that it's inbuilt in sentencing. I'm going to look at the CPS policy. And the employment example is another example. The employment laws are our means of justifying an employment decision that is capable of engaging Article 8 but would not make a claim.
Right.
So, my lords, that's Rasgar. I'm going to show you, if I may, Lord Justice laws in a case called Wood, which you'll find in volume 6, same volume, tab 52.
Sorry, 42, did you say?
52, my lord.
52, thank you.
MS 2054. The issue in this case was whether taking of photographs of the applicant by police officers was in breach of Article 8. All three members of the court, Lord Justice Dyson and Lord Collins, agreed that Article 8.1 was engaged. The majority agreed that there was a breach. Lord Justice Laws is in the minority, but I want to show you passages with which the court, in his judgment, with which the court agreed. And if we could pick that up, please, at paragraph 19, MS 2066. His Lordship having considered a series of cases about Article 8.
Was it the taking of the photographs or the retention which was in issue?
It is the retention of the
it's the retention,
photographs.
yes.
I'm so sorry.
Right. I think the taking was
I
accepted.
think both, actually.
Not
from
to oddly
recollection.
enough. One of the things that Article 8 doesn't reach.
Well,
Sorry,
there was quite a debate about that in a case that I see isn't cited, and that's JR 38.
Correct.
Where this court split, but in fact the majority approved, from recollection, what Lord Justice Laws had said.
Well, I'm sorry we haven't put that before the court.
Sure.
But could I just take you to how Lord Justice Laws deals with this in a passage that all the Court of Appeal agreed with? So we're at paragraph 19, 2066. These cases and others show the contents of the phrase private and family life is very broad indeed. Looking only at the words of the article, one might have supposed that the essence of the right was the protection of close personal relationships. While that remains a core instance and perhaps the paradigm case of the right, the jurisprudence accepted many other facets, so many that any attempt to encapsulate the right scope in a single idea can only be undertaken at a level of considerable abstraction. But it is an endeavour worth pursuing, since we need, if possible, to be armed at least with a sense of direction when it comes to disputed cases in the margin. The phrase physical and psychological integrity is, with respect, helpful. So is the person's physical and social identity, and other references there given. These expressions reflect what seems to me to be the central value protected by the right. I would describe it as the personal autonomy of every individual. I claim no originality in this description. Sir Anthony Clarke referred to Lord Hoffman's emphasis in Campbell. The law now focuses upon the protection of human autonomy and dignity, the right to control the dissemination of individual about one's private life, and the right to esteem and respect of others. The notion of personal autonomy of every individual marches with the presumption of liberty in a free polity, a presumption which consists in the principle that every interference with the freedom of the individual stands in need of objective justification. Applied to the myriad instances recognised in the Article 8 jurisprudence, this presumption means that, subject to the qualifications I shall shortly describe, an individual personal autonomy makes him and should make him master of all those facts about his own identity, such as his name, health, sexuality, ethnicity, his own image, of which the cases speak, and so also of the zone of interaction between himself and others. He is presumed owner of these aspects of his own self. His control of them can only be loosened, abrogated, if the state shows there's an objective justification for so doing. So, my lords, taken with the other authorities that we set out in our written case, that sets out my first point, which is the very broad nature of rights that focus in.
Yes, paragraph 28 is rather important, isn't it? Because your opponent relies on the qualifications which Lord Justice Laws then introduces.
Absolutely, absolutely, my lord. And I was going to then ask you to stay with this case of Woods when we turn to my second point under Article 8.1, which is that it's a low threshold for engagement, but there needs to be a careful distinction with justification. And if we could look, please, at paragraph, in fact, if I could ask the court to read paragraphs 22 to 26.
Yes, but that's not on justification. I mean, 22 is on whether it's engaged. Must attain a certain level of seriousness, and then the important
Well, if you come on to the third point, my lord, you'll see that...
Yes, must enjoy on the facts a reasonable expectation of privacy.
Yes.
And then, as you say, the question of justification.
Yes, and my lord, I'm so sorry, I haven't made myself plain. If the point I'm seeking to make by reference to paragraphs 22 to 26 in this judgment is my second key point under 8.1, which is it's a low threshold, and you shouldn't confuse the test under Article 8.1 with the test under Article 8.2. And that's the point that His Lordship is making very clearly in those paragraphs.
But the reason why in Wood he had a reasonable why he had Article 8 was engaged was that he was doing nothing wrong, walking around his lawful business in the street and taking and retaining photographs of him didn't infringed something in respect of which he had a reasonable expectation of privacy. What is said in this case is that if you are using false documents, you don't have a reasonable expectation of privacy.
And that's why I'm going to come on to that, to demonstrate that you can't provide that answer because it ignores the Section 31 defence and the context, which is why SXH was presenting with a false document, and the context that it is long understood that is a readily understandable means by which people seek refuge, now and in the past.
Well, I think your argument is that you can't take a snapshot of what she was doing at that precise moment and regard that as being comprehensive of her claim to a right to respect for her private life. I mean, that's like taking a still from a film and focusing on one moment in time when a much broader canvas is appropriate.
It is unacceptably myopic to view the act of the presentation of false documents as simply a presentation of false documents. It's a presentation of false documents for a purpose and in a context that has been well understood both in international law and accepted in domestic law as to why people present false passports. And I'm going to come on shortly to show you the well-known description of the rationale that was given by Lord Justice Simon Brown in Ademi.
I mean, supposing they'd discovered that she was not a genuine asylum seeker at all, that there hadn't been any persecution, would that have altered the position?
Well, if it would be perfectly proportionate, and one can see in the public interest, it is perfectly proportionate and in the public interest to prosecute people who, with no legitimate justification, seek to enter this country on false documents. There's no part of my case to say that Section 25 is on its face incompatible with the Human Rights Act. It's obviously right that the state has a power to prosecute.
So if the facts had turned out to be, they'd discovered in March 2010 that in fact she wasn't a genuine asylum seeker,
yes,
then what? That would have retrospectively changed that?
No, yes. I mean, that's why we put our case in that. One of the main ways we put our case is that what should have taken place is that it should have deferred the decision to prosecute until they'd ascertained her refugee status.
Well, that's a separate point. For my part, I understand it. But what is the answer to the question? Focusing on the decision as in December, does it become good if subsequently it turns out that she hasn't got the defence?
Yes, because it would be deemed to have been proportionate, objectively.
But it's still an interference. But it's still an interference.
It's still capable of engaging Article 8.1.
Well, no, not capable of, does.
I beg your pardon. it still would engage Article 8.1.
Okay.
But the respondent would ride home on Article 8.2.
Well, if reasonable expectation of privacy is to be regarded as a touchstone about which I've expressed significant doubts, but let's accept for the argument that reasonable expectation of privacy is the touchstone, and let us further accept that the touchstone is to be interpreted as an indispensable criterion, both of which are of dubious validity. But let's suppose that that's right. Well, then arguably the person who comes in with no legitimate claim to refugee status at all and presents false documents in order to gain admission to the United Kingdom doesn't have a reasonable expectation of respect for his or her private life. And therefore, Article 8 is, on that thesis, not engaged at all.
Well, that would be right, my lord, and there's going to be a range of, it's going to be fact sensitive to some degree, and certainly our case is that if you come in and you do have a Section 31 defence, you have a reasonable expectation of privacy. If you're coming in by subterfuge because you want to commit a crime in this country, then you're right at the other end of the scale. Now, there may be cases in between, but this appellant's case is clearly at the far end of the scale because she did have a legitimate reason for presenting a document. So, my lords, at the moment I'm just trying to show you the thinking on the low threshold and the need to separate out the question of 8.1 and 8.2. Could I just show you, so that's paragraphs 22 to 26. Could I just show you, my lord, Lord Hughes in Nicholson, and the distinction between the two that my lord drew? We'll find that in volume 5, tab 41, MS 1502. And the passage is at paragraph 262, which is MS 1693.
Not likely to be authoritative in this context, I don't think, is it? Anyway,
well, my lord, what it is, my lord, is we would say with respect, a helpful drawing out of the constituent parts of Article 8.
Yeah.
And so we'd just ask the court, please, to read paragraphs 262 to 264. Could I then move to my third point, which is the broader concept of engagement because of the consequences of a decision to prosecute. And my lords, we say this: a decision to prosecute an individual is a coercive act by the state, which forces the individual to account for his or her actions, even putting aside the impact of custody if bail is refused, as it was here. Each step in the prosecution process, from being kept for questioning, to having to attend court hearings, to have to give an account of your actions, to facing the prospect of trial and convictions, are factors that impinge upon the autonomy of the individual and therefore engaged Article 8. And the point can be made by contrast. This court has recently held that stopping an individual at an airport and compelling them to answer questions under Schedule 7 of the Terrorism Act engaged Article 8. For your note, see my Lord, Lord Hughes in Bagal, Volume 2, Tab 17, Paragraph 28, MS 616, where my Lord said there was rightly no dispute that Article 8.1 was engaged. Now, the Court of Appeal in this case, in this appeal, acknowledged that the decisions, that the consequences of a decision to prosecute can engage Article 8. We see that at paragraph 12 of their judgment at MS 4085. Sorry, that's yours.
Right, what's the MS number again, please?
4085, my lord.
4085. Paragraph 12.
Sorry, that was paragraph what?
Sorry, it's not paragraph.
It's not 12.
It's not paragraph 12. It's paragraph 71.
71. Yep.
Where his lordship
Diffidently disagreeing with Lord Hoffman.
diffidently agreeing with Lord Hoffman.
And Lady Hale, I think.
Well, we're going to come to that in a moment, and I'm going to seek to demonstrate that Lady Hale's analysis was much narrower than Lord Hoffman's. For example, and then there's a disagreement. And his lordship says, for example, if the prosecutor is aware of facts that provide the suspect with an unanswerable statutory defence to the charge, it seems the decision would not only be perverse but might constitute interference. But then secondly, a decision to prosecute a dying woman may constitute a disproportionate interference with her private life. And that must be because of the consequences of a decision.
That's odd. I mean, why should it only be a dying woman?
Well, quite.
So, I mean, logically, the second proposition is, or is the emphasis on the word disproportionate?
Yes, I think so.
I mean, if we're talking about engagement, as we are in paragraph 71, it seems to be muddling it up with justification.
Precisely, my lord. And we say with respect that is an error that is found.
So you would delete the words dying, and you'd probably delete the word disproportionate, because it's dealing with engagement. You would say a decision to prosecute anyone may constitute an interference with private life because it's very upsetting.
Yes.
I mean, you get a letter from the revenue, that's very upsetting.
Well,
is that an interference with your private life?
My lord, no. I think a letter from the revenue is unlikely to actually. There's a threshold for Article.
It's certainly. Let's suppose you get a letter from the revenue saying, "I want to investigate these transactions, which go back 10 years. It takes you 10 hours to demonstrate that there's absolutely nothing in the revenue's inquiry." Is that an interference with your private life? It's prevented you going off and doing a lot of things with your family.
I would say that is unlikely to reach even the low threshold of Article 8.1. But even if it did, one can see how it would be justified in a matter of seconds. It obviously precedes pursues a legitimate aim, and it's hard to see how sending that type of letter could ever be deemed to be disproportionate. That, though, is not this case, and it's not a prosecution case where the implications of a decision to prosecute are so more profound. And we set out in our written case that prosecution services, not only our own in England and Wales, but really in many countries, recognise the impact that their decision-making has upon the autonomy of individuals, which is why we've set that out in our written case. But Lord Justice Pitchford identifies the correct principle, because in the example of the dying woman, he is recognising that the consequences of that decision on that individual are such that Article 8.1 is engaged. Where, with respect, he goes wrong is to say that it is limited to those sort of extreme examples, because there is no reason in principle why it should be, and also because he wrongly elides the question as to whether or not Article 8.1 is engaged with whether or not it was infringed. And so, correct to say consequences are capable of engaging. Incorrect to say that that's a threshold of the nature that he identified. Could I turn to the narrow basis upon which we put engagement for Article 8? Which
is there any authority for this proposition about consequences? I mean, we're talking about convention rights, and it's suggested we should be cautious in going further than the Strasbourg court has done. Is there any... we've read your cases, and it appears that there is really no authority supporting this proposition, is there, in this breadth?
Well, my lord, the underlying principle is one that we would say is trite and doesn't need authority, which is that where a public authority acts in a way, in a manner that has consequences for any of the convention rights of an individual, it's for that authority to justify them, if it's a qualified right. And you don't need Strasbourg to tell you that, any more than when we look at sentencing, where the courts have identified that the sentencing process itself engages Article 8, but its very nature satisfies Article 8. The courts didn't need Strasbourg to tell them that.
You say that we need a Strasbourg approach, and you say the CPS is a public body. Those two propositions are plainly right. There are many countries, perhaps most countries, who are signatories to the Convention, where the prosecuting department fall within the judiciary and are regarded as part of the judiciary, whether it's a French examining magistrate situation or many others. And therefore I am wondering whether the mere decision to prosecute in a case where the offence is convention compliant, and at least in a case where there is evidence of having been committed, falls within the ambit of a lack of respect for somebody's private and family life, when it's a step really in a judicial investigation. Put in terms of a question, is there any Strasbourg authority supports the idea that a decision by an examining magistrate to conduct a criminal process comes within the ambit of showing a lack of respect for the person's private and family life? Are there any Strasbourg authorities which help?
Not that I can take my law to know.
Right.
There certainly is authority in Strasbourg to the effect that, and the reasonableness of the expectation of privacy is a factor, one in a number of factors which can determine whether or not Article 8 is engaged, or whether the particular sphere of activity comes within the ambit of Article 8. And to revert to my Lord's question to you about a letter received from the Inland Revenue, it may well be that that is a factor which looms large in the decision whether or not Article 8 is engaged, because as citizens we must expect that the Inland Revenue will conduct research into possibly dubious claims to tax exemption, to take an example, and that therefore that is not a constraint upon one's private life, because there must be some restriction on the scope of private life. And I would have thought that your submission is that looking at the consequences of a particular public authority's decision is simply casting another perspective on the question of whether there is a constraint that is acceptable on private life.
Yes, my lord. Mm-hmm. Yes. Could I move from that broad conception to the narrower conception, which turns on the analysis of both the High Court and the Court of Appeal, which was that, save for exceptional circumstances, it's only permissible for the court under Article 8 in these circumstances to look at the alleged criminal act itself and no other relevant circumstances.
So this is the nature of the act approach.
This is the nature of the act approach. So thus the courts below concluded that Article 8 couldn't be engaged because Section 25 of the Identity Cards Act itself did nothing to interfere with the appellant's private life, nor was possession of a false document an expression of personal autonomy or the expression of enjoyment of a private life. My Lords, I've already really made many of my submissions under this point. We say it's an artificially myopic approach, not least in circumstances in which you can't even on the statute book look at section 25 in isolation. You can only look at it together with the complete defence under section 31 and the rationale for section 31, which was to reflect the fact that there are genuine and legitimate reasons why people will enter to seek refuge and asylum with false documents. And there is no doubt that that is what the appellant was seeking to do. Now, that has long been an act which has been recognised as one to which respect should be accorded. And perhaps the clearest expression of that is in the judgment of Lord Justice Simon Brown in Adini. Can we briefly go to that, please, which is in Volume 1, Tab 3. MS 68. And if we could start, please, in page 673 at the outset of His Lordship's judgment. At MS 74. His Lordship, the problem facing refugees in their quest for asylum needs little emphasis. Prominent amongst them is the difficulty of gaining access to a friendly shore. Escapes from persecution have long been characterised by subterfuge and false papers. And then you see the memorandum from the Secretary General, and then the terms of Article 31. And over the page, His Lordship said, the need for Article 31 has not diminished. Quite the contrary. Although under the Convention, subscribing states must give sanctuary to any refugee who seeks asylum, subject only to his removal to a safe third country, they are by no means bound to facilitate his arrival. Rather, they strive increasingly to prevent it. The combined effect of visa requirements and carrier liability has made it nigh well impossible for refugees to travel to countries of refuge without false documents. And then if we could just turn on, please, to 78, MS 78, page 677 of the report, and just below letter G, His Lordship says, what then was the broad purpose sought to be achieved by Article 31? Self-evidently, it was to provide immunity for genuine refugees whose quest for asylum reasonably involved them in breaching the law. In the course of argument, the judge suggested the following formulation: where the illegal entry or use of false documents or delay can be attributed to a bona fide desire to seek asylum, whether here or elsewhere, that conduct should be covered by Article 31. That seems to me helpful. That
go to 676H, please. The respondents acknowledge one striking fact.
I'm sorry. My friend asked me just to direct your attention to the preceding page, 77, 3 lines below letter G.
676.
676, below letter G.
MS 77.
Where His Lordship paused to note one striking fact. The respondents acknowledged that until these challenges were brought, no arm of state, neither the Secretary of State, the DPP or anyone else, had apparently given the least thought to the United Kingdom's obligations arising under Article 31. I'm in fact going to come back to that when I look at Article 8.2.
Well, that certainly didn't apply by 10 years later, so I'm not sure why.
Well, I'm going to come to the history of it when I come to Article 8.2 in the particular context of this
Section
case.
31, the defence, was created largely as a result of this decision, wasn't it?
Yes,
Yeah.
yes. So, sorry, I was just taking you to the purpose of 78. So we're on page of Article 31, at the bottom of MS 78. Nor is it disputed that Article 31's protections can apply equally to those using false documents as to those characteristically refugees of earlier time who enter a country clandestinely. And then, as we've already trailed this morning, at page 679, between letters B and H, His Lordship deals with the issue as to presenting yourself without delay. In light of time, can I just flag that for my Lords and move on to ASFL, which was before the Lords after Section 31 of the 1999 Act had been...
I mean, probably, in the present case, I think there is a possible inference. I think there's some suggestion that, in fact, if your client had been successful in presenting herself as the person in the passport, she would have not claimed asylum at all. She would just have disappeared into the internals of this country and existed on that basis.
No, her evidence, which was accepted, was that she was going to claim asylum. She was going to find.
But she was going to go to a police station.
She was going to go to a police station to claim asylum, and that was
Thank you. Okay.
no challenge to that. And also, my lord, the court had evidence that what happens with Somalis, they had it from an experienced immigration solicitor, again, unchallenged evidence, that what happens with Somalis who manage to get through the airport documents is that they then attend to claim asylum for the UKBA, and they are not prosecuted. Could I take you then just to AS4, please? So we're in Volume 1, Tab 4, MS 99. And it's paragraph 9 in the opinion of Lord Bingham, which my lords will find at MS 117. And his lordship, at paragraph 9, identifies the three broad humanitarian aims of the Refugee Convention. The third aim, just above D, broadly expressed, was to protect refugees from the imposition of criminal penalties for breaches of the law reasonably or necessarily committed in the course of flight from persecution or threatened persecution. It was recognised in 1950 and has since become even clearer that those fleeing from persecution or threatened persecution in countries where persecution of minorities is practiced may have to resort to deceptions of various kinds, possession and use of false papers, etc., in order to make good their escape. Effect was given to this third aim in Article 31 in the terms set out.
Drawing the threads together, is it your submission that anything which affects a person's private life in a more than minimal way involves interference with respect for it within the meaning of Article 8?
Well, I think we put it in a slightly more diffuse way, my lord, which is that Article 8.1 will have a low threshold. I'm not sure that more than it's a de minimis text.
Well, first of, you give the example, if you bump into somebody inadvertently, Lord Justice Laws's first exception has to meet a certain level of seriousness.
Yes.
That was all I was intending to cover by that. So anything which affects somebody's private life and which gets over the minimal level of seriousness is an interference with respect for it within the meaning of Article 8.
Yes, that's the wider proposition.
That's the proposition.
Well, Lord, just to be clear, that's the wider proposition. It's not the proposition that I'm
I'm
advancing a narrower proposition.
Yeah, you say there's an alternative one. Right, so effectively, every time there is a criminal investigation of somebody, that automatically brings the person investigated and anybody else involved into, it involves an interference with respect for their private life.
The prosecution, certainly.
Yeah. Well, a criminal
implications that the prosecution... sorry.
Well, why not an arrest? There may be some interval of time between arresting and charging.
Yes.
But it'd be difficult to say, well, it only arises at the moment of charge, wouldn't it?
Well, an arrest can certainly capable of engaging.
But anyway, if the criminal, but in a sense it matters not, if the criminal investigation is capable of having an impact on their private life above that threshold level, then that investigation will involve an interference with respect to their private life.
Potentially will, yes. But
and also anybody who is caught up in the process, those who are, if the matter were to go to trial, jurors who have to attend, witnesses who have to attend, people who have to produce documents under subpoena. This would be for all of them.
Well,
yeah.
Because the test is ultimately a simple one on the broad proposition, which is it an act of a public authority that is having crossing the low threshold of an impact on the personal autonomy? Now, does this mean my lord, that suddenly, if that proposition were to be accepted, that suddenly there are going to be breaches of human rights.
This is your Article 2 point.
Are they? Yes.
I'm trying to see whether there was any, whether you were contending that Article 8.1 is as broad as I had understood, and you've confirmed you are.
Well, yes. On my broad proposition, it is broad, and it would capture. We say entirely unremarkably.
Yeah.
Acts of public authority that impinge upon the autonomy, as understood in the prism of Article 8, on the autonomy of individuals. And as I've already said, that's unremarkable, and it does not lead to any new claims. It does not lead to any change in the way that public bodies go about making their decisions.
I mean, the alternative is that there are many activities by a public body which may interfere with, but don't involve an interference with the right to respect for. What value attaches to the word respect in Article 8.1?
Well, that's my alternative. That's why I'm on the narrow proposition here, because it accepts, under my narrow proposition, that it's got to be an act that is worthy of respect. And my argument under this narrow proposition is that that's satisfied here, and the Court of Appeal and High Court were wrong in analysing the act merely as a criminal act of presenting false documents and not looking at it in the proper context. But, my lord, I'm going to come again on. I'm sorry to keep stressing this point, but I'm going to come when I come to Article 8.2 to seek to demonstrate that even though there may be a low threshold in Article 8.1, meeting that, justifying that, will not require public authorities to act in any way other than they already do. And I'll show you in respect to the CPS, it's already the process that they apply when they make decisions as to whether to prosecute. So nothing radical, nothing revolutionary.
Now, you've got to ask for, Mr.
Got to ask for. I was going.
Can you just tell us what you're trying to get out of it? Because you're on the proposition now, as I understand it, your narrower approach to Article 8, that the underlying act is a private one, to use an ellipsis. And are we going to get that out of as for?
Well, what you're going to get is worthy of respect.
Right.
And it's an act taken with Adimi and Asfor.
Because Asfor went off, didn't it, on the construction of the statutory defence in Article 31.
It did.
And it was extended effectively to the charge which was there in question, which is a charge of dishonestly attempting to obtain a flight.
It did. My Lord,
so could it also have been Article 8?
Well, but
could Asfor have been decided as an infringement of Article 8?
Well, can I
of course.
come back to you on it? What I am relying for Asfor and Adimi on is the broader proposition that the act that SXH was undertaking when she presented a false passport at Stansted cannot properly, for our purposes, be analysed solely as an attempt to, by criminal means, to enter the United Kingdom. It can only properly be seen in its full context, which is, here is a young refugee fully entitled to enter this country, only able to do so by subterfuge, because it is agreed that if you are a Somalian, you will not have a travel document.
You say fully entitled. I mean, that's something that wouldn't be known at the time. If she wasn't a genuine asylum seeker, she wasn't entitled to enter the country. So you're looking at it with the benefit of...
But was Article 8.1 engaged by those acts? Can you simply judge it by what was in the knowledge of the person who made that prosecuting decision, who didn't know about the refugee status? We say no. The question objectively is an objective question. Was Article 8.1 engaged by the decision to prosecute? Was it an act worthy of respect? And there you have to look. You have to look at the context.
Well, no, but do you have to look at the facts as they're subsequently established, or aren't you compelled to look at the facts as they were known at the time?
Not on the question of engagement. Not as to whether an act of prosecution.
Why not? I mean, surely we're talking about right to respect, which is necessarily something integral to a relationship between two people, someone who's alleged to benefit by the right, someone who's alleged to have infringed it. And so surely don't we have to ask, look at the context in which those two people were acting at the time they acted?
No, you ask objectively, was the act one worthy of respect? That
So
is not
you
worthy
look at
of...
it with hindsight then? You look at it as to what we know now the facts are?
What was in fact the case? Was it an act that was worthy of respect? You can't judge whether it was an act worthy by respect by what was in the mind of the particular person at Stansted Airport who held her, or the prosecutor who made the decision. But was it an act worthy of respect? And we say, of course, a refugee with her experiences, her inability to ever obtain travel documents, the acceptance since Ademi, entrenched in international law since the 1950s, recognising that this is how people will do it legitimately in order to escape persecution. Of course it was an act worthy of respect. Well, also, I was going to turn, if I may, to my fifth point under Article 8.1, which is to respond to my learned friend's case, that there can be no breach of Article 8 for a prosecution where the offence itself is Article 8 compliant. In other words, on my learned friend's analysis, provided it's not necessary to make a declaration of incompatibility in respect of a particular offence, then in no circumstances can a decision to prosecute for that offence engage Article 8. As I've already said, it's not our case that Section 25, not least when read together with Section 31, is not Article 8 compliant. Plainly, we accept the offence is not disproportionate on its face. But the question as to whether or not Article 8 is capable of engagement at all by a decision is not answered by an assessment as to whether or not the underlying offence is convention compliant.
Mr. Hammer, before you go into that, shall we have a very short break? Yes, Mr.
My Lords, could I, although I'm very mindful of the limited time I have left, can I just go back to a question Lord Mance raised about the test under Article 8.1, whether or not this is an objective test?
Yes.
Or there is an element of subjectivity in it. My Lord, we obviously maintain our position that it's an objective test for the reasons that I gave. But even if it were there was an element of subjectivity in it, then on the facts of this case, we would say it was met. And that's because the evidence demonstrated what the CPS knew at the time of the charging decision, because they had been given the details that the appellant provided in her screening interview. And for your note, you'll find that starting at MS 4251, it included that she was just a day over 18, that both her parents were dead, that she was a member of a minority clan.
Right, yes.
She came to the UK because of safety for my life, because there's a war in Somalia, and she said, I'm in fear of my life because the situation is still worse. And this is someone who was seeking asylum. And so, my lord, even if, contrary to our primary submission, you can introduce an element of subjectivity into a test under Article 8.1, we say it's met here. Just to go then back to my fifth and final point under Article 8.1, which is the point about whether or not you need an offence. The Article 8 is limited only to asking whether the offence itself is convention compliant. My lords, I've shown you already Lord Hughes' analysis to how to say, for example, taking cocaine is capable of engaging Article 8.1. It will be easily and readily justified. A perhaps even more stark example is provided in the Strasbourg jurisprudence in the case of Stubbings against Germany, which you'll find in Volume 8, tab 64 at MS 2580. This is a case in which the court held a prosecution and conviction for incest was capable of engaging an Article 8 right. See, in particular, paragraph 55, MS 2590. Otherwise, rather than take you to the case,
Is it the individual prosecution, Mr. Hermer, or is it the criminalisation of the behaviour?
it's the prosecution. If you look at paragraph 55,
It's the individual. Okay.
Well, wait a minute. It's conviction, isn't it?
no, if you go on, my lord.
Yes. Where?
Oh, I'm so sorry. Yes, I'm so
The
sorry.
court doesn't exclude
Yes.
that the appellant's criminal conviction had an impact on
Yes.
his family life and possibly attracted protection under Article 8, as he was forbidden to have sexual intercourse with the mother of his 4 children.
In any event, it is common ground between the parties that the applicant's criminal conviction interfered with his right for respect to private life, which includes his sexual life.
Yes, I see.
But the court considers there's no reason to hold otherwise and endorses this assessment. So the criminal conviction thus interfered with the applicant's right.
Does that answer Lord Hughes's question, whether the relevance of Article 8 was because of the nature of the offence rather than the fact of its prosecution?
Yeah.
Well, my lord, we would say it appears to be the prosecution, but as ever, well, perhaps not for the first time, it's not entirely clear
Right.
from the decision.
The distinction between the first 2 sentences is mysterious,
Yes.
isn't it? I mean,
But-
it's unclear whether they're both talking about consequences, or one is talking about consequences and one is talking about the nature, or what the position is.
Well, I suppose the first sentence is dealing with family life.
Yeah.
And the second is dealing
I
with
see, yes, it's
private
private.
life.
Might be
and that's the distinction, is it? Yeah.
They're talking about the nature of the activity,
So it's
which
nature,
is the subject of prohibition, aren't they?
Yeah.
Looks like it.
Yeah.
Well, can I then just...
And the footnoted cases are effectively to the same effect. I mean, criminalisation of homosexuality in Dudgeon and Lasky, sadomasochism.
It's a bit,
Well,
in international terms, analogous to the celebrated US Supreme Court case in Lawrence and Texas.
Yes.
Yeah.
Yes. I mean, there's nothing in my submissions to suggest that Article 8 has no room for challenging the compatibility of legislation. And, for example, if legislation was to be introduced that sought to criminalise homosexuality again, that would be, we would say, amongst other things, a breach of Article 8. But our point is that that is not the exclusive domain and the exclusive reach of Article 8 in the realms of criminal justice. And as a matter of principle, that must be right, because if it were not, it would give the CPS a form of immunity. As long as the offence for which they are prosecuting is itself convention compliant, it doesn't matter what the impact of their decisions would be. It doesn't matter how irrational the decision, might be, how little evidence there might be for it, what the consequences might be in the most dire scenarios, such as those posited by Lord Justice Pitchford. So, my lords, we say as a matter of principle that just simply has to be wrong. There's no principled reason for drawing a line around Article 8 that says the only thing courts can do is ask themselves whether the offence itself is Article 8 compliant.
Well, isn't a possible principled reason that if the offence is Article 8 compliant and there's evidence that's being committed, the launch of an investigation, which may involve an arrest, is not of itself something which by its nature involves a lack of respect. It may be that the conclusion of the investigation is, for all sorts of reasons, there should be no finding against the person. But is that not a possible principled approach?
We say no, because not least, my lord. One of the conclusions of the investigation is the decision to prosecute, which engages for the reasons I've set out, or is capable of engaging for the reasons that I set out, the Article 8 rights of the person who is being prosecuted. And I'm so sorry, Mike.
No, I was just going to say, picking up this decision before we put it away, it's inconsistent with your argument about consequences, isn't it? Because, firstly, they appear to be looking purely at the nature of the act, the subject of the prosecution. But secondly, actually, if you look at the consequences in relation to him, they were quite severe. He was sentenced to imprisonment in terms of, well, it appears a matter of a year and a bit. So he could say, if consequences were relevant, that prosecution led to dire consequences for my family life or private life, but they didn't refer to that at all as a basis for engagement.
They didn't. But that doesn't appear to be how it was argued either. I'm not sure. My lord would say it doesn't undermine anything that I'm saying, but it's not authority for that particular proposition.
Right.
It's more proposition for the engagement of Article 8, notwithstanding that the offence itself.
Yeah. Right.
My lords have my point on that. But the key point is one of principle, and the highest it can be put, as we see it on the respondent's case, is reliance upon the House of Lords decision in G.
G, yes.
And my lords will find that in Volume 1, at tab 6, MS 189. Of course, I recognise that my submissions cannot be squared with the judgment of Lord Hoffman.
Right.
And Lord Hoffman, the heart of Lord Hoffman's judgment is at paragraph 10, that's MS 195.
Yes, well, he's very clear in his usual fashion.
Yes.
Where he says prosecutorial policy and sentencing do not follow under Article 8.
Yes.
So, and you several times said sentencing does. Have you?
Yes, I'm going to come shortly, if I may, to a decision of the Court of Appeal in the case of Petherick, which my Lord Hughes gave the judgment of the court.
Right.
So we say Lord Hoffman wrong on sentencing, wrong on prosecutorial authority, and it appears from the second sentence that, with great respect, his lordship wrongly elides the question of engagement and justification. Prosecutorial policy and sentencing do not fall under Article 8, sentence 1. If the offence in question is a justifiable interference with private life, that is the end of the matter. Well, my lords, we agree. If it's justifiable.
No, but he means, doesn't he, if it's a legitimate, if it's a justifiable decision to criminalise this kind of behaviour. Isn't that what he means?
Yes.
I think
there's nothing wrong with the offence.
That might be. But, I mean, the long and short of my submissions are that the Lord, for the reasons I've set out, Lord Hoffman is wrong.
Yeah, let's follow that.
Lady Hale's analysis was far narrower than Lord Hoffman's. At paragraph 54, her ladyship didn't consider what she considered to be the real complaint in the case, namely the fact that the offence of which the appellant was convicted bore the label rape, was capable of engaging Article 8. because there was no doubt that penetration had occurred.
Sorry, paragraph?
54.
Thank you very much.
The better view, we would say, is the analysis of Lord Hope, with whom Lord Carswell agreed, at paragraph 34. And my Lord Mance appears to have accepted that Article 8.1 was capable of engagement, but concludes, see paragraph 67, 68 and 72, with the majority that it was a proportionate.
Assumed might be a better word than
Assumed.
accepted, might it not?
Well, I'm not going to dispute that with my lord.
No.
Assumed. I'm happy with... certainly my lord didn't doubt that Article 8.1 was capable of being engaged, or didn't set out any reasons of principle why Article 8.1 could not be engaged by the decision to prosecute. Sorry to take this at speed, but I'm conscious I haven't yet got to 8.2. The case then went to Strasbourg, Volume 1, Tab 7, MS 212. It's obviously only an admissibility decision, but the court concludes that since the subject matter concerns consensual sex, it was prepared to accept that the case engaged Article 8.1, but then concluded it was entirely justifiable. Key paragraph is 35. So we say, taking the 5 judgments as a whole in G, they don't amount to authority for the proposition that Article 8.1 has a more limited scope in the realm of prosecutions. The only other case to which we draw your attention under this heading is one that I'm afraid we haven't put in the bundles. It's a decision of the Administrative Court of Lord Justice Moore-Bick, sitting as a single judge. I'm just going to hand it up, explain it, and give you the references, if I may. We hand it up because it's a case in which a victim brought a successful Article 8 claim against the CPS for failing to prosecute.
Thanks very much.
So it looks at this issue from the other end of the telescope, albeit through the positive obligations to protect under Article 8.
Thank you.
With your permission, can I simply give you the paragraph numbers, relevant paragraph numbers, which are 20 to 21 and 24. And for your note, it may be worth cross-referencing to the respondents' floodgate arguments. See in particular footnote 26, MS 4040. My Lords, can I turn now to Article 8.2 and the question of justification? My Lords, I've repeatedly tried to stress that concerns about floodgates can be allayed because inbuilt into decision-making, not only at the Crown Prosecution Service but in other public authorities, are procedures that mean that decisions that impact upon others will, in the vast majority of cases, be proportionate. And these are procedures that, in many cases, long predate the coming into force of the Human Rights Act. I'm going to give you 2 examples. The first is the one I've already advertised, which is sentencing. And then the second, which is the respondent's own policy-making decision procedures. Sentencing, my Lords, the sentencing process itself ensures that the decision will be proportionate. And that is because a judge will take into account all the relevant circumstances during a sentencing process. It's what it's designed to do. It considers not least matters put in plea or mitigation, so the impact upon a defendant, and it balances it with all other relevant factors, not least the seriousness of the offence. We do rely in this respect on the judgment of the Criminal Division in the case of Petherick. That's Volume 6, Tab 43.
MS?
MS 1735.
Thank you.
The general principles are set out by my Lord, Lord Hughes, and the relevant paragraphs are 17 to 19, and the conclusion at paragraph 25. Starting off, His Lordship, we do think, however, we ought to say these brief things by way of general observation. First, the sentencing a defendant who has a family inevitably not engages not only her own Article 8 right to family life, but that of her family, and that includes...
Wait a minute, wait a minute. I know you're in a hurry, Mr. Hermer. The Article 8 rights in question were not the defendants, were they?
No, my Lord, but you recognise...
Do I go on to deal with that?
Well...
This was about this was a case of a defendant who said, "You've forgotten to take into account my dependent child." Yes.
Yes, my Lord.
Okay.
But if my Lord looks at 17,
Yep.
we'd respectfully submit you are anticipating here both
Okay.
the rights of the family and the rights of the defendant, and we would say with great respect, rightfully so. So my Lord says we do think, however, that we ought to say these brief things. The sentencing of a defendant who has a family inevitably engages not only her own Article 8 right to family life, but also that of her family. And then my Lord goes on to say, well, there's really nothing remarkable about the fact that it's readily justified, because that's what criminal courts do. They take into account, when they are sentencing, all the relevant factors, and that equates to a proportionality test. And my Lord, if a criminal sentence engages the rights of the family member, it must, for the same reasons of principle, engage the rights of the defendant. But that is going to be justified and proportionate, and the reason we know that is because that's what the sentencing process does. So, my Lord, the relevant paragraphs we say are 17 to 19 and 25. Can I move on, if I may, to the CPS's, the respondent's own decision-making process? As the court knows, there's the Code of Crown Prosecutors, which requires them to consider two aspects. Firstly, an evidential test. Does the evidence make a successful prosecution likely? And secondly, and distinctly, the public interest test, which is it in all the circumstances in the public interest to prosecute? Almost by definition, that's a proportionality, that's addressing itself to issues of proportionality. That's in the code, but since this case, and for the last few years, the CPS has itself had in place a policy that mandates that decision makers go through a step-by-step human rights analysis. And we can see that, it's in the appendix, it starts at MS 4408. So it's headed Human Rights and Criminal Prosecution's General Principles. Just over the page, MS 4409, you can see it notes that it's a public authority for the purpose of the Human Rights Act. Prosecutors must apply principles of the European Convention on Human Rights in accordance with human rights at each stage of a case. If you just mark, if you would be so kind, the next paragraph as well about what this means. Over the page, 4410, towards the bottom of the page, effect of relevant ECHR articles on the prosecution case.
This is all, this is 2013.
It's 2013.
And indeed the Code for Crown Prosecutors, which is quoted there, is the 2013 edition, isn't it? The one which is set out in your case, written case, paragraph 30, is not the one which was in force at the date of this these matters.
That's right. That's right, madam.
It's the January 2013 version. The one in force appears actually at page 4382.
I'm very grateful.
Which is in different language.
Yes. No. But still, the essence of my point about the code, which is that inherent in it is a proportionality analysis. So I was just showing you the paragraph under the heading Effect of Relevant ECHR Articles. Prosecutors and those who support them in casework need to be aware of convention rights, vigilant in spotting potential breaches. Over the page, it's noted that there will be civil liability under the Human Rights Act. And then can I ask the court to go to Annex B, which is in 4418, which provides a checklist for those reviewing a case involving a human rights issue. Requires considering whether the evidence passes the evidential stage, then the public interest stage, then at question 3, asking whether the prosecution will engage anyone's convention rights. Will a prosecution result in the restriction of a convention?
I think that sometimes it won't.
Well,
Don't they?
my Lord, that is implicit. And, my Lord, although I have advanced a very broad conception under my consequences heading,
Yes.
I don't mean to submit that every single prosecution is inevitably going to reach that low threshold. So if in respect of a qualified right at 6, is there a legal basis, is there a restriction, etc.?
You presumably have to accept that my point about context is relevant here. It can't depend upon what the actual facts are or may turn out to be, unless an acceptance as far as they're known to the Crown Prosecution Service. They have to form a judgment as to whether the prosecution will engage anyone's convention rights on the basis of their information at the time.
Proportionality must obviously incorporate what they did know, but proportionality must also, we would submit, incorporate what they should have known.
Well, that may be slightly different. What people should know can count as their knowledge. Can I just ask you on that? You're pursuing the Crown Prosecution Service, but I think your written case suggests that they answer or should answer for what the UK Border Agency knew or should have done. Is that right?
Well, we put it in a slightly different way. We say, as a matter of principle, if you're seeking to justify your actions as a public authority, that you can't seek to blame another limb of state.
Why not?
Well,
I mean, you're only answerable for your own actions if you're the CPS.
Well,
if you want to sue the government at large, you have to adopt a different mechanism, or you have to join the UK Border Agency.
Well, my Lord, I think the highest way we put that case is the way it was run on the facts below, which was insofar as the respondent said, well, there was information we did not have. What was said is you should have had that information. We explored in evidence the links that were between the UKBA and CPS, the flow of information between them, what was the institution of knowledge compared to the other. So, my Lord, I think for our purposes, I can rest it on at that highest point.
So it depends what the CPS should have asked.
Should have known, yes. Because you can't justify your actions if you've been willfully blind. You can't justify your actions as proportionate if there was information that you knew you should have obtained but did not.
Thank you, yes, that's helpful.
So, my Lords, I show you the CPS policy, not least to reassure you that the appellant's case does not require a complete reworking as to how the respondents conduct prosecutions in this case. And also to reassure the court that because there are procedures, because we have the Code for Crown Prosecutor, because the CPS recognises the impact of the human right, it is overwhelmingly likely that in the vast majority of cases, decisions to prosecute will be readily demonstrable as proportionate, such that only the reckless foolhardy or perhaps extraordinarily rich would ever seek to challenge most of those on that basis. Now, what makes the appellant case different is the context. And the context, the important, essential context, is because the decision to prosecute was made in the context of years of systemic failures in the prosecutorial system, leading to prosecution of refugees who had entirely valid reason for entering the United Kingdom with no documents. The context of systemic failures, contrary to our international law obligations and contrary to our domestic law duties, the consequences of which have been borne almost by definition by some of the most desperate and vulnerable members of society.
Can you support, by some hard evidence, that proposition that of systemic failure over the years, regular prosecution of refugees? It may be in the papers, but just...
No, I'm going to come to it
Right.
and hopefully assist the court. And we can trace it chronologically because we know that when the divisional court dealt with Adini, there was a systemic problem. My learned friends already alerted you to one passage in the judgment of Lord Justice Brown, who also described the cases before the court at MS 77 at page 767b as being but the tip of the iceberg. 9 years later, when As4 comes before the House of Lords, Lord Bingham took some reassurance from the fact that when Parliament gave effect by legislating Section 31, the aim had been for this to be a defence of last resort. And there was greater reassurance taken by the fact that it was intended to be part and parcel of administrative measures that would prevent cases coming before the courts in the first place. And my lords will see that in paragraph 24 at MS 124. The High Court in this case had evidence that the aim at that stage had been to promulgate a joint interagency approach to guide to good practice, together with partners such as the Law Society. Well, was that, as the evidence below established, never happened. At the date of the appellant's prosecution, all there was a policy document, which you'll find at MS 4398, which gives only the most generic explanation of a Section 31 defence. Now, since that time, there have been continuing systemic problems about which the respondent is fully aware. I'm afraid one document that didn't make its way up to you but was before the court below is the report of the Criminal Cases Review Commission of 2011 and 2012. Yeah, of course. Sorry.
Thanks.
We set out an extract from the, firstly from the chair's forward, and you should have, it's page 5 of the document, bottom right-hand corner, and it's talking about classic miscarriages of justice. And if you could look at the last full paragraph on column 1 on page 5, in terms of miscarriages of justice, illustrated by our recent identification of a series of cases where refugees or asylum seekers have been prosecuted for and pleaded guilty to offences relating to their entry to the UK, such as having a false passport or not having a passport. Some even found themselves in the almost Kafkaesque position of being punished for arriving without a passport, having fled from a country whose passports are not recognised by our own government, precisely, obviously, this case. And then there's some analysis on page 15 of cases of this nature. And in light of time, could I just ask my lords to mark up all of page 15 through to the end of the first paragraph, first column of page 16. Matters do not appear to have improved since then. In the bundle, volume 9, tab 75, MS 2915, is a letter of February 14 from the chair of the Criminal Cases Review to the Guardian. That's 2915. Your report on a Syrian asylum seeker made for pretty grim reading. I cannot comment on that case, but I can tell you that the wrongful criminal prosecution of genuine refugees has been all too common in recent years. And then, again, because of time, could I just ask my lords to read that, the whole of that letter, in due course? And to turn on to tab 78, MS 2955, which is the most recent CCRC annual report, and at 2969, you will see at the bottom of the page and over the continuing concerns under the heading Prosecutions of Refugees and Asylum Seekers. Continuing concerns with the criminal division of the Court of Appeal continually having to face cases of this nature. So, my Lord, it's on that basis that we submit that this appeal can be properly said that the context is very different to the vast majority of prosecutions. Because here there is a systemic problem with prosecutions that are producing a series of miscarriages of justice in a way that is contrary to our international and domestic law obligations. The case of this appellant was not a one-off failure that can be justified in isolation as falling within the margin of discretions of particular decision makers. Rather, the question as to whether or not the respondent can justify the decision, either to prosecute or not to postpone the prosecution pending the outcome of the asylum application, can only be assessed in that context. As seen in that context, there are at least three respects in which the acts and omissions of the respondents led to a decision to prosecute that cannot be justified as necessary or proportionate. The first is premised on the judge's findings that had the decision maker known that Somalis could not attain travel documents, then the prosecution would not have proceeded, or presumably, the judge didn't say this, presumably would have awaited determination of refugee status.
Sorry, the judge found that had...
He didn't actually quite say that.
But which paragraph are you referring
Might well have altered the decision, was what he said.
We also need to see paragraph 92, my Lord. I think my Lord has paragraph 43.
43 I'm on.
So if we look at 43, which is MS 4100,
Oh, yes, yeah, two things, yes.
so he deals with this at 43,
Yes.
and then again at 92, which is for MS 4110. Which is in slightly more absolute terms.
Well, it's more absolute because it's... Because it deals with the Yemeni situation, doesn't it?
Well, that's, my Lord, that is right.
Yeah.
But the clear thrust of the views of the learned trial judge was that this was a material information that, at its lowest, may well have had an impact.
Yeah.
But the evidence before the High Court was that the CPS did know. Now, that might be thought unsurprising in light of its own caseload, not least before the criminal division of the Court of Appeal. But the evidence was that they did know, and they'd taken no steps to disseminate the institutional knowledge to the decision makers in immigration cases.
Where's that?
You'll find that in the evidence of Miss Bowen, who was a senior policy advisor at the CPS. She was cross-examined.
Bowen?
Bowen.
Yeah.
She's cross-examined, and the relevant passages in the transcripts are MS 4241D to 4242F and then again at page 4245 between A and C.
Has the judge made any findings about this?
He did not.
I mean, he's found that the CPS didn't know, hasn't he? Effectively.
Well, my lord, I think in terms of generally, he says there's information that they should have got from the UKBA.
No, but he's focusing. He said, had the CPS been advised by UKBA,
Yes.
and the UKBA were clearly aware, but never
Yes.
informed the CPS. So the inference is.
Well, my lord, there's
vital
no
facts. Yes.
there's no dispute that the caseworker or the caseworkers did not know.
But wait a minute, didn't know what?
Did not know that Somalis would not be able to obtain travel documents to enter the United Kingdom.
Oh, documents, yes. Right, so this is about documents rather than the Yemeni.
This is about documents. This is not about the stay in Yemen.
Right, thank you very much.
So the decision makers themselves did not know, but the evidence was that the CPS had knowledge of that, unsurprisingly, because of the cases that they would be involved in.
Well, you're asking us to make findings which the judge hasn't made, are you? I mean, is this was this argued in front of the Court of Appeal?
Well, I want to obviously be very sure that it was, so I will check. But can we work on the assumption that it was? But remember, this is the respondent who needs to demonstrate proportionality and justification.
Yes, but we take the facts normally from the judgment, and if you're asking us to make further findings, we have to be sure of the basis.
Well,
of
because
it.
what I can submit to my lord is that was unchallenged evidence. There was no dispute. I mean, unsurprisingly, it came from the respondents themselves. That was their evidence. This was their witness talking about the institutional knowledge and position.
Well, at its minimum, you say that the CPS has not made the case in support of its avowed justification that it did not know.
Yes, we accept that the decision makers and the individual
Yes, but
decision
that the
makers.
CPS as an institution
Yes.
isn't asserting that it didn't know that.
No. Exactly. Well, that is the minimum, is how we put it.
Your case is presumably, is it, Mr. Hammer, that they really ought to have told their local prosecutors, at least, I suppose, where there are ports in the area, for each country, I suppose?
Well, yes.
Yes.
So certainly a means. It might not have. I mean, it's not for me to make an allegation of negligence, but certainly certainly.
Well, eventually.
But I mean, let me have a go. Certainly a means by which a decision maker is going to realise that there's an issue that needs to be, with some answers need to be given in the context, and this is why the context is so important, in the context of over a decade of miscarriages of justice. Now, the second failure was a failure to comply even with its own code under the public interest test, and to have regard to any of the factors that militated against a prosecution being in the public interest in respect of a prosecution on an individual who, on any view, was vulnerable. That element of the public interest test was not considered until Ms. Sternberg took over the case in June 2010 and got on with the job. And in the email that you have seen, set out why she didn't think it was in the public interest to prosecute. Now, the decision to prosecute did consider the public interest test, and we can see that at 4357. This is the decision to charge made on the 28th of December 2009, and you can see public interest test halfway down the page, where the factors that are considered in the public interest are the seriousness of offence, the significant sentence that's likely, and the positive impact on community confidence. I don't say for a moment that those are not legitimate things to consider in the public interest, but what is not considered at any stage is the personal circumstances of the prosecution. And this is notwithstanding the fact that the CPS knew at least at this time the information from the screening interview, which was sent to them. I've shown you that, MS 4251. She's an orphan. She's in fear for her life. She's only a day over 18. And indeed, by the 19th of February, see MS 4296, through a skeleton argument served for a remand hearing, 4296 at paragraph 4, the CPS provided with further information about the particular vulnerability. I'm sorry, I've given you the wrong page reference. I'll correct that in a moment. They're given 4297.
7, yeah.
Thank you. At paragraph 4, they're given further information.
As a matter of interest, it really is almost idle curiosity. Did anybody ever make an application for bail for this woman?
There was no application. No.
Not even an application? Okay. I mean, there would have been a number of difficulties, but on the face of it...
Well, my Lord, it must be thought almost inevitable that where the Crown opposed bail in respect of somebody in the appellant's position, that they were going to be remanded into custody.
Well, it depends what the alternatives are. Anyway, don't worry, there's no point in arguing it now.
Why? I mean, what is the what would be the grounds actually of opposing bail?
Well, she'd had no fixed abode
Roots and ability.
and might run away. So the question is, where else could she be accommodated? That's what you'd be looking for.
Perhaps, because remember, her asylum application hasn't been dealt with, so it might be that she could have relied upon the goodwill of a non-governmental organisation to assist.
Yes.
But that is speculation.
I mean, genuine, as she clearly is, a genuine refugee often does have exactly that kind of support on arrival. But there we are. It didn't happen in this case. All right.
And also, my Lord, I accept, not least because the CCRC make it plain, is that the fault of all these miscarriages of justice is not one that rests solely on the prosecution. It also rests entirely on those who represent defendants.
Most of the complaints, yes, exactly that. And most of the complaints about not being advised about the existence of Section 31.
Yes.
Yeah.
So, my Lord, we say in light of those facts, it's very difficult to see why consideration was not given to the public interest in prosecuting this individual, or at least delaying the prosecution pending the outcome of her her asylum application. And the court again had evidence from Miss Bowen that it would have been possible to delay the prosecution, and that there was nothing preventing the CPS from obtaining evidence from the border agency as to the likelihood of asylum being granted. Now, can I again give you the references as to possibility of delay? See MS 4238G to 4241C. As to the free flow of information with the border agency, see MS 4223B2H.
Sorry, say that last one again, please.
4223B2H, my Lord. My Lord, the third feature of the case that inures against the decision to prosecute being deemed proportionate is that, notwithstanding the context, each stage of the decision-making was marred by confusion and mistake, rendering it very difficult for the respondent to demonstrate proportionality. And indeed, it is telling that it's only when Miss Sternberg took over the case that in 7 days, through diligent researches of her own, not by liaison per se with the UKBA, she reached the decision that the prosecution could not be made out on the evidential test and the public interest test. See the description of her work by Mr. Justice Irwin, paragraph 34, MS 4097. prior to that point, there'd been, as I say, a litany of mistakes. The prosecution was initially based upon an erroneous decision that the brief stay in Holland deprived the appellant of a Section 31 defence, see MS 4360. It took a month for the CPS to flag up whether that was right, 4361. The response on the 5th of February, 4326 from UKBA, that it was seeking more guidance. By the 21st of March, so we're 3 months into custody, the UKBA's position was that because of ASVOR, the case should be dropped. See MS 4329. Nothing happens then until the 26th of April, until the UKBA email the CPS recommending that the case be discontinued, 4336. And at that stage, on the 29th of April, 4338, the CPS's response, which appears to accept that Holland isn't relevant, seeks clarification for the first time about Yemen. So Yemen only arises at the end of April. And on the 4th of May, the CPS recommends proceeding not on the basis of Holland, but on the basis of Yemen, on the mistaken, albeit irrelevant basis, that Yemen was not a signatory to the Refugee Convention. And on the 10th of May, the UKBA accepts this advice, 4341. Now, for my Lord's note, we set out a full history of the relevant decision-making in a note that was before, as an appendix to our skeleton before the High Court, MS 4433.
4433.
And of course, my Lords would have picked up in all of this that right at the outset, as Mr. Justice Owen recorded at paragraph 14 of his judgment, the respondent's initial position is to offer no prosecution if the appellant returns to Holland. Was that the CPS or the UKBA? Was that CPS or UKBA? I'm so sorry, I think that was the UKBA who offered that. Now, to meet all of the arguments on proportionality, the respondent argues that it is, in all cases, essentially going to be proportionate to push ahead with a prosecution, irrespective of what might happen on an asylum application. That, we say, with respect, is an argument with deeply unattractive consequences, because implicit in it is an argument that it would have been proportionate to prosecute the appellant to trial if her refugee application had not been processed beforehand. And it is, of course, possible that a jury might have wrongly decided that she was not a refugee and been convicted. Now, all of that is an acceptable price to pay on my learned friend's submissions, because the crux of their argument on justification is we don't wait if the Section 31 defence isn't absolutely made out. My Lords, I'm coming to the end of my time, but I'm just going to give you one more reference, if I may, which is to a system in place, the system in place in Scotland presently for dealing with cases such as this. Obviously, just because another system does things differently doesn't mean that it's disproportionate here, but it meets the point about all the policy concerns that are raised by my learned friends. You will see that in Authorities, Volume 10, Tab 81, MS 3034. Can I ask you in particular, please, to look at paragraphs 11, 23, 26 to 29, 31, and 34 to 6. My Lords, unless I can assist you further, those are my submissions.
Thank you very much indeed. Mr. Thomas. Thank you. Yes, Mr. Havers. Oh, I'm going to have the interveners first. Yes, you're quite right. That's Mr. Hussain.
My Lords, UNHCR is extremely grateful for having been granted permission to intervene in this case, and I am grateful to my learned friends for accommodating 30 minutes from me. As we say in our printed case at paragraph 4, that's MS 4580, and consistently with our mandate, UNHCR doesn't address the application of Article 8 to prosecutorial decisions in general, but focuses on the application of Article 8 to refugees who have used false documents as part of a quest for asylum. May I please ask you to take our printed case as read? Our overall submission at paragraph 8, MS 4583, is that it will normally be a breach of Article 8 to prosecute a refugee for the use of false travel documents, where such use is integral to a quest for asylum. That, of course, needs some unpacking, and I would propose, with your leave, to address the following issues. First, briefly, the reasons why Article 31 is relevant to the engagement question. Secondly, the reasons why Article 31 is relevant to justification under Article 8.2. Thirdly, and I'll propose to spend more time on this, the requirements of Article 31, which is, of course, the lex specialis protection for refugees presenting false documentation as part of their quest for asylum. And then lastly, or fourthly, the failures in the appellant's case, which demonstrate what we respectfully say is a general systemic failure to deliver Article 31 in the UK since Ademi was decided. We endorse my learned friend's submissions on the point. Indeed, we make them at paragraph 73 of our printed case. And finally, some sweeping up points. So the first issue is Article 8.1. We address this in our case, paragraphs 87 to 92, MS 4616 to 4624. We say Article 8.1 is engaged on whichever approach is adopted. We support the appellant's approach, and we also submit that the merits of the prosecutorial decision can be relevant. In that sense, we go further than the appellant at paragraph 111, because essentially, if there are no merits or very weak merits, the indication is that there is no criminal conduct. And that leads me to my learned friend Mr. Havers's proposed test. His test is whether the conduct is worthy of respect in the sense that the individual has a reasonable expectation of engagement in it. Well, in this context, it of course is worthy of respect. The individual not only has an expectation of engagement in it, he's now got a legal right. It's not criminal conduct. You've got to look at the offence holistically. If you look at the offence just in terms of its essential ingredients without the defence, then it cannot be justified. And Parliament clearly thought it couldn't be justified. It would have enacted the defence. If you look at the defence together with the offence holistically, it is clear that the appellant and those who are covered by Article 31, essentially, there is some mismatch. I'll come on to that, but point made by my Lord Hughes. Those people haven't engaged in criminal conduct. Indeed, the conduct in which they've engaged is contemplated or protected by Article 31. And therefore, it is, on any view, we respectfully submit that in the case of refugees travelling on false documentation who are protected by Article 31, there is a very clear case of engagement under Article 1.
That begs the whole question, doesn't it? I mean, well, obviously, if they'd known that Article 31 was Section 31 and Article 31, then it would have been quite wrong to prosecute. But
it's an objective test for the simple reason
that brings us back to a point that was argued by Mr. Hermer. But
it's an objective test for the simple reason that if you're looking at it at a reasonable expectation, that introduces immediately a standard of objectivity And if there is an
A
entitlement...
reasonable expectation
Yes.
surely looks at a standard of objectivity from both sides, doesn't it? I mean, you can only complain that you haven't been given a reasonable expectation of privacy as against someone who realises what your position is and that you have a reasonable expectation. Yeah. If to all appearances you don't, for example, you may be insane, but you haven't raised that defence until the criminal trial 2 years later. How are they to know that that's the position?
I will make submissions on the absolute imperative need for proper systems to be in place. It's very clear that that's required as a matter of international law. And the systems ought to have picked up.
Well, that's a different point.
It's a related point. And also, my lord, with great respect, if you are loading everything into 8.1, what room is left conceptually for 8.2? There's nothing. If you're saying they must have known, it must have been absolutely clear, subjectively they must have known, there's Article 31, that you've got engagement and breach. It's the vice that you were criticising the Court of Appeal for that's been committed here, with great respect. You can't load everything into engagement. We respectfully submit.
But I don't think anyone's suggesting you do.
The way we put it is that questions of facts emerging, when they do, why they do, late, goes into 8.2. That's how we put it. The further point is, as Lord Kerr said, that the still from the film, my learned friend, his myopia, you have to ask why the conduct was engaged in. It is totally wrong, and indeed, with great respect, faintly ludicrous, to sever the presentation of a passport from the reasons for it. Article 31 requires you to do that, apart from anything else. The section requires you to do that. My learned friends point to an analogy. They say you can't ask the reasons. That's at 141 of their case. At 142, they point to an analogy, and they say, well, if you can look at reasons, you could say that theft in order to visit family members abroad, that would be covered because that engages private life. That is an unattractive and inapt analogy. There is no international law right to theft, and nor is that a defence. It's obvious. Other analogies in my learned friend's case, with great respect to him, are also inapt, indeed offensive. The analogies are animal cruelty, domestic violence, cannabis cultivation, underage sex, attendance at dogfights. And you have that, respondent's case 51, 73, and 108. This is, legally speaking, a sui generis situation. Refugees are sui generis in this regard. Article 31 is absolutely unique in international law. There is a moral case for other people in need of protection. In that sense, there isn't this sui generis aspect, but legally there is. You will not find the analogue of Article 31 in the ECHR and the ICCPR. It's not even in the Stateless Persons Convention. It's absolutely unique. And that leads me on to the point that it's very unsurprising, if my lords were to conclude that Article 8.1 is engaged, that would be very unsurprising. It would be absolutely orthodox, because as my lords will be aware, you have the famous Al-Atsani principle derived from the Vienna Convention on Law of Treaties, Article 31.1c, which says that, effectively holds that Article 8 falls to be informed by other relevant rules of international law. And we put the points in our printed case at paragraph 91, MS 4621. And of course, Article 31 is very clear, was not considered by the courts below on this issue. It's a very important issue. We say it's absolutely straightforward, with great respect, in this particular context. On 8.2, I'm going to be brief on 8. On 8.2, we say, in our printed case, that Article 8.2 will be breached where there is a breach of Article 31, either a breach or a prospective breach of Article 31. I'll develop what I mean by that in a moment, save in unusual cases. And that's our printed case, 93 to 99, MS 4624 to 30. What do I mean by that? It's exactly the point that my lord was putting to me a moment ago, Lord Mats. Facts may emerge during the prosecutorial process, or post-trial following conviction, or following review from the CCRC. And that may lead to justification, provide justification under 8.2. But that is premised on proper systems being in place that are robustly applied. Whilst now the position seems to be that there are reasonable systems in place. If you look at our case at paragraphs 71 and 72, we describe them. 71 is the current CPS policy. The historic policy seems to have been woefully deficient. I'll just give you the references to it. It begins in the core volume at MS 4398, and the relevant extract is in the middle of the page.
Sorry, give me that again, please.
Sorry, my lord. MS 4398, and it's beginning in the middle of the page, MS 4405. That's the relevant page. Well, the policy at the material time. Did you get that?
Sorry.
But we say...
405.
Sorry, my lord. 4405, 4,405.
Thank you very much.
And the relevant paragraph is in the middle of the page, fifth paragraph beginning, it remains the case. We say that's a very weak iteration of the policy. What you've got now is much better, but quite apart from design, there are very serious operational problems. They are not the sole responsibility of inadequate legal advice, although that is, of course, a contributory factor, as the courts have recognised. But there is a serious operational problem in our respectful submission, indicated by the points my learned friend made. So, provided you've got a proper system that is robustly applied, that doesn't pick up the defence or the Article 31 question, in that situation, we accept that there could be justification. But if you haven't got that, we say it is difficult to see what the justification could possibly be for prosecuting an individual who is protected by Article 31. I now want to move on to my third topic, which is that in this case, and this case is a good example of a protected class under Article 31. That's our case, paragraph 5, MS 4591. In this case, we say Article 31 was breached or would have been breached if she'd been prosecuted to conviction. My lords will be alive to the point about penalties. I'll come on to that. You don't need to decide it. It doesn't matter, because either way, the appellant would have been prosecuted for conduct that's contemplated by Article 31. And we put the point more fully as our primary submission, our secondary submission. In our case, at 8.10, that's our summary, MS 4585, and at paragraph 96, MS 4626. It doesn't matter, because under Article 8, it doesn't matter. There's an important point as to what penalty means. You've got our submissions in our printed case at paragraphs 48 to 60, MS 4599 to 4605, paragraphs 48 to 60. We don't need to decide it. I'll take you to some passages in that section of our case in due course, because they emphasize the importance of systems. But the issue of whether or not Article 31 is legally was breached, or whether the appellant's conduct was protected under it, is important for the reasons I gave a moment ago. It's even more important now because the respondent appears to contest this in the early part of my learned friend's case. That's respondent's case 2124, 2531 Roman 2. Even though...
You'll have to go a bit slow.
Sorry, my lord. 21, 24, 25, 31, 2, Roman 2. 21, 24, 25, 31, Roman 2. Even though the respondent accepts, as is very clear from the emails which my learned friend showed you, that the prosecution was discontinued both on public interest and evidential grounds. Respondent's case 31, Roman 4 and 32. So...
Sorry, you're saying respondent's case?
Yes. My learned friend's case.
Yes, I see.
Mr. Havers' case.
Yes, I see.
He accepts.
Yes, I'm with you.
We respectfully submit he's adopting,
Yeah.
he's riding two horses that are pulling in completely
Yes,
different
I see.
directions, that are inconsistent with what his client actually thought. He's saying, actually, it wasn't met, the defence wasn't met, Article 31 wasn't fulfilled, but he accepts that the discontinuance was both on public interest and evidential grounds. So let's consider, if I may, the constituent elements of Article 31. Because, and this will be important because it addresses some very important issues that my Lord Hughes has raised today and also in the Court of Appeal on the interrelationship between 31.1a and 31.1c. That is to say, without delay and the need to claim as soon as reasonably practicable. Now, my Lord Hughes said, well, she sought to cross immigration control on her false instrument. Why not simply, when you arrive in the immigration arrivals hall, not use it and stop there? Well, my learned friend gave two answers, a human answer and a legal answer. We absolutely agree with him, and I want to drive home why those answers are absolutely solid. The human answer first. It is well accepted that refugees in flight cannot be taken to have immigration law expertise and may mistrust border officials. Lord Shepherd of Liverpool, I'll just give you the reference, I won't take you to it now, in the House of Lords, expressed the view that many refugees will be fearful of officialdom. The reference is Volume 9, Tab 71, MS 2846. Admittedly, he was saying, why is there the need for 31C? I accept that. The response from Lord Williams, the Attorney General, was, well, it's our solution. It's part and parcel of the A question. And when we come to the legal materials, we'll see that's very clear. 31.1c, or the authority of ASFOR, does not add anything. But I want to carry on developing the human point, because my learned friend said that refugees may be traumatized on entry. My Lord Reid said that is not the approach to criminal law. Well, we respectfully submit that is not the view of the promoting minister. Again, Lord Williams, in House of Lords Hansard, Volume 971, MS 2849. I don't want you to take it there, to take it up just now. Indeed, said that 31.1c is both objective and subjective, and one needs to take an objective view as to what is subjectively reasonably practicable. And he precisely drew the comparison between somebody who was claiming refugee status on the basis of an apprehended threat of persecution on the one hand, and a person who'd been tortured on the other. Here, of course, we have an orphaned rape victim who was just past majority when she arrived. Of course, one needs to look at the individual situation in order to assess what is reasonable, whether asylum has been claimed as soon as reasonably practicable. The Scottish guidance, which we say is, with respect, an excellent model of how things ought to operate. There are some problems with it in terms of reverse burden. I'll come on to that in a moment. But generally speaking, it's an excellent model, which we would commend on behalf of UKSC. You have that at Volume 10. I'll just give you the reference. Volume 10, Tab 81, MS 3041, where the Scottish guidance says, in terms, that the reasons for delay can include the effect of trauma. Trauma is, of course, very commonplace for refugee claimants, and we've set out in footnotes some relevant materials on that point. I'll just give you the references again. Printed case 90.1, footnote 68, printed case 90.3, footnote 73, MS 4619 to 4620. So that's the human answer. There's a very clear legal answer to this point as well. And in fact, my Lord, almost word for word, if I may say so, repeated what he said in the Jaddi decision. And in Jaddi, my Lord had said that in very general terms, in the great majority of cases, there will simply be no excuse for a genuine refugee not to make himself known immediately he arrives in the first safe place. That is to say, the arrivals immigration hall. In the subsequent case of Mateta, which you have, we don't have Jedi in the authorities. It's actually appended to the Scottish guidance. I don't want to take you to it. I can just refer you to the Mateta. The subsequent case of Mateta you have at volume 5, tab 38, MS 1463, Lord Justice Leveson, we say with great respect, he was correct to say that my Lord Hughes's observations in the Jade case were not intended to detract from principles in ASFOR or other authorities. They do no more than make clear the very real importance of focusing on the facts. What I do want to take you to, perhaps I can do it after the short adjournment, is the ASFOR decision.
Yes. Well, shall we do that? Then we'll adjourn till 2 and look forward to your further 10 minutes. Then, thank you very much indeed.
Thank you.